Alright, greetings and salutations everyone. Sorry if this video is not really the best quality. This is my shot. I'm taking it. Here we go. On October 17th, I made a trip from my location, which is 3 hours away from Austin, to go visit my boys. And I brought my 1-year-old with me, their little brother. And on the way back, taking consideration, I had already been driving about 5 hours total that day, having woke up super early so that I could leave on time and make it there. I had spent over an hour running around on a playground with my children and spending time with them, and then get back in the car and have to drive 3 more hours. By the time I was driving through Santa Ana, I was tired. The baby was sick of being in the car and starting to cry. I had to use the restroom really bad, and I was 12 miles from my home. So I was slowing down going through this small town, but not fast enough, because I just really wanted to get home. There was absolutely no pedestrians in sight anywhere. I don't even remember seeing any cars necessarily, because like I said, it's just a small town. You blink and you're through it. And I was slowing down, but they wrote on here I was going 46 and a 35. Okay. So this is and at the time, the only driver's license I had was a Nebraska state driver's license. And this will prove a couple things to you guys, that by signing a driver's license, it's a contract for the state, which is all capital, capitalize the state of Texas. When it's written all capital, that's the corporation. I know a lot of people are learning this and probably hear the same things over and over, but I can't stress that enough, because if you look on this paperwork, the name that's written down is all capitalized. The very top of it, citation and Santa Ana Police Department, is all capitalized. These are corporations. It's one corporation charging another corporation. They're conducting commerce and trying to exchange currency. So moving on, that was the original citation. So I showed up to the municipal court, and I had this pre-written. I didn't know my docket number, so I just left that part blank. And when I got there, I asked the clerk. So she gave me the number. I wrote it down just like that with pen. I wrote those little dots down the middle, or dashes, or whatever they are. I wrote my name and thumbprinted it with, I thumbprint with red ink and I signed with blue ink. There's a lot of different ways people say to do it. Like purple means this, blue means that, red means this, gold means that, black means this. I've just settled on, I like blue ink when I'm signing my name, and I like red for my thumbprint. I'll save that for another day. So this notice is the only thing I showed up, and they're expecting I'm just going to pay the fine for the ticket. And the clerk hands me a piece of paper, and it's got like 3 choices on it. Do you plead guilty, not guilty, or no contest? And I asked her, I said, what about a trial by jury? Where is that on here? And she goes, oh, you want a trial by jury? And I was like, yeah. So she kind of like hesitated. And then I think she went back to the back room and like talked to probably the judge herself, actually. Because this is a really small town. I don't even think they have a courthouse. I mean, this place looked like a concession stand. It looked like I was going to go and order a hot dog and hand her some money or something, because it was just, there. I don't think there even was a courtroom. So she comes back and she goes over to a filing cabinet or a bookcase or something, some kind of shelf or something, and she gets me a separate piece of paper and hands it to me. And I was like, wow, that's really kind of sneaky, that most people that come in here wouldn't even know you have to ask specifically for that, or you won't even know that you have that option. So I was kind of suspicious. So I sign that. I sign it, all rights reserved with prejudice, such and such, whatever, under necessity without recourse. Any number of one of those. I don't really exactly remember how I signed that. And then I handed this this was the last thing I did. I handed this to the clerk and told her I wished to file this on the case. So it says, notice, I, Catherine, a woman, require the man that claims I do wrong to come forward before the court and verify that this is true. I got this idea from Carl Lentz, and I really do like it. We've been successful, like me and my husband have been successful using this for these little tiny traffic tickets, because if you're requiring a man or a woman to come forward, that's going above the title of officer. They're going to have to actually have a living man, someone willing to put their own liability on the line, that what they're saying is true under penalty of perjury. And doing wrong is different from breaking a code, a rule, a regulation, or a policy. If you do wrong, it means you hurt somebody or you hurt their property, like you damaged a stop sign, you ran somebody over, you ran over their dog, or you scratched their car, you stole something that didn't belong to you. Like any of those things, those are wrongs. And that definitely didn't happen by going 46 and a 35. So also, I'm saying I need to have someone claim I do wrong come forward before the court and verify that this is true, because verification is superior to certification. Anybody can get something certified. You just take a piece of paper to the public notary and say you want to get this certified. Even a lawyer can do it, whatever. But to verify something, now you're going to have someone put their hand on a Bible and swear that they're telling the truth. And they are also going to have to swear under penalty of perjury. So it's like a totally like next level thing. Someone would really have to say like, no, I know this person hurt that lady, ran her over, and I'll even swear on the Bible that it was true, that kind of thing. So I knew that no one was probably going to come forward and do that. So this was the correspondence that I received in the mail from the city prosecutor. Notice how it's written in all capital. This is a corporation. Okay. And so she sent it to me, because I had a Nebraska license. They had my Nebraska address and my Texas address. I'll show you the actual envelope at the end. I've also scanned that and redacted my private sensitive information off of it. So she sent it to both before realizing I just have a Texas P.O. box. So I get this. Dear Ms. Roach, Governor Greg Abbott issued an order that no jury trials were to be held when you made your request for a jury trial due to the COVID pandemic. If you had requested a bench trial, you would have been found guilty based upon the evidence. You do not qualify for a deferred adjudication in this case because you were traveling 10% over the posted speed rate of speed. This violation occurred on or about October 17, 2020 in the middle of the city of Santa Ana, Coleman County, Texas. You may tender a check in the amount of $285 payable to the city of Santa Ana. This cashier's check must be received on or before January 29, 2021 in the municipal office of the city of Santa Ana to avoid the issuance of a warrant. Also, it appears you're in violation of Texas law, which requires you to get a Texas driver's license within 30 days of moving to the state of Texas. It is important that this check be received in the Santa Ana office with a mailing and physical address of 709 Wallace Avenue, Santa Ana, Texas, 76878. Thank you sincerely, Elizabeth O'Connor. Okay, and see, she CC'd it over to the court clerk and the court judge, Shirley Rankin. All right. Now, when you first get something like this, like your first reaction is your like heart sinks and your stomach flops and you're like, oh crap, what am I supposed to do now? I mean, literally, like you get a frog in your throat seeing that they want to pay you, or they want you to pay them $285. They said you're already guilty. You can't have a jury trial. Like it looks horrible at first glance. I mean, and then she's like, oh, you also didn't get a Texas driver's license within 30 days, so we're going to also get you for that. So anyone that doesn't know what I've figured out would probably be really upset by this and probably at that point go, this stuff doesn't work. I'm just going to go pay it. I know so many people that would just do that. They'd be like, crap, okay, I guess I'll just go pay it. But right off the bat, I knew this was full of crap. Governor Greg Abbott issued an order that no jury trials were to be held when you made your request. Okay, when you, at the time, the very first thing I did was I Google searched it, trial by jury, Texas, or something like that. And it actually said that they were holding jury trials or trial by juries through Zoom. So I was like, okay, they weren't canceled. You know, she's trying to say there's no jury trials being held. Then the second thing, and this is an even stronger point, is written into the Texas Constitution, Article 1, Section 15, I believe. It says that the right to a trial by jury shall be inviolate. It can never be canceled. To do so, someone would be committing treason and going against the Texas Constitution. So that right off the bat, like, see, when you get educated and you start breaking stuff like this down, you can spot someone lying and poker bluffing. Okay? So then there's even more about this, but let's just move on. Actually, I'm just going to double check and make sure it's still recording. Okay. I look crazy. Anyway, all right. So this is what I sent. This was my conditional acceptance, okay? And I sent one to the prosecutor, I sent one to the court clerk, and I kept a copy for myself. And if you'll notice up here in the corner, I've got a bracket. This is kind of a next level way of a whole bunch of your paper. I believe it's like actually maritime law or admiralty or something like that. But regardless, it's just kind of a little bit more serious than a staple. So it's like, oh crap, okay. Because think about the lengths you would have to go to like even know that, and also to have purchased brackets. It's just kind of funny. But anyway, okay. So got the docket count number. Okay. Dear Mr. quote unquote officer and or quote unquote prosecutor, in regards to the above citation and case, I wish to resolve this matter to the best of my ability as soon as possible. I find it necessary to exhaust by due diligence my administrative remedy as it relates to your presentment and offer to pay $285 by way of check or have a warrant placed upon my debtor. I would absolutely love to take care of any debts verily owed. It actually said truly owed, but I love the word verily because I always think of the Messiah when he says verily, verily. So I just changed it. You know, like, I think people get so hung up on like cookie cutter, like completely copying word for word the way that people say things, but like make it your own. Make it your own based on like everything you've ever learned in your entire life. Put your own personality and character into it. Okay, so I said I would absolutely love to take care of any debts verily owed. So I wish to conditionally accept for value your offer and charges predicated upon proof of claim. And I promise and solemnly vow to pay the fine on behalf of the alleged debtor that you have brought the charges against, but I can only do so conditioned upon such verifiable proof of claim, given under penalty of perjury, and as such, the necessary proofs of claim are exculpatory and sought on behalf of the alleged, whoops, sorry, I forgot that my new computer is touchscreen. Okay, and sought on behalf of the alleged plaintiff enumerated below so that the alleged debtor may justly ascertain liability in the interest of plaintiff, the court, and public interests, to perform accordingly, touching upon the performance of the law relative to due process of law to which the debtor is presumed entitled, regarding a fair and impartial hearing within the due course of the law as it appertains to this proceeding or any other related matter hereto, according to the following to wit. Okay, we don't have any knuckles to crack. Number 1, proof of claim on how the Texas Constitution operates upon I, a private woman. Number 2, proof of claim on how the state statutes by and through the Texas legislature and the DMV operate upon I, the private woman. 3, proof of claim that name appearing on the charging instrument in capital letters, Catherine Marie Roach, is not a corporate fiction, but is the name of the private woman in her private capacity. Proof of claim that the Texas Transportation Code describes any other class of license other than for commerce or for commercial trade, occupation, or profession. 5, proof of claim that in my private capacity that I am subject to Class A, B, and commercial driver's license, see Texas Transportation Code 7B, Chapter 521A. 6, proof of claim that the state of Texas via the DMV sells any other driver license. 7, proof of claim that the Motor Vehicle Code does not operate upon all drivers of all vehicles owned or operated by the United States, this state, or any county, city, district, or any other political subdivision of this state, and thus operates upon this private woman. 8, proof of claim that my private automobile is not a recreational vehicle that is operated solely for personal and private use. 9, proof of claim that my private automobile is used for the transportation of persons for compensation or profit, or designed or used primarily for the transportation of property for hire. 10, proof of claim that the prosecutor is enforcing the license issue solely due to the private woman acting for compensation upon the highways. See Schmog versus Kaiser, 189, California, 596. 11, proof of claim that in view of this rule, a statutory provision that the supervision officials may exempt such persons when the transportation is not on a commercial basis means that they must exempt them generally applies in this matter. State versus Johnson, 243P, 1073, 60 CJS, Section 94, page 581. 12, proof of claim that the prosecutor, officers, and employees of the state of Texas or the city of Santa Ana are bound to support Article 1, Section 10 of the Texas Constitution. And proof of 13, proof of claim that the officers and employees of the state of Texas or the city of Santa Ana are bound to support Article 1, Section 15 of the Texas Constitution. 14, proof of claim that the secured party has access to lawful money of account to pay debts at law without becoming a tortfeasor. And 15, proof of claim that the prosecutor, as an agent of the state, has established a liability bond, either personally or by and through any risk management policy in this action, to indemnify the private woman in the event of any damnification, and I require the policy number and the address of the insurer and bonding company. Whew. So, number 12, Article 1, Section 10 of the Texas Constitution, and Article 1, Section 15 of the Texas Constitution, as you can tell, I put those on separate lines. You really want to separate your facts like that, because they're going to have to rebuttal each and every fact. So you wouldn't want to just kind of rope them all in the same one. But also, one of those is the right to a speedy trial by jury. I think it's trial by jury. Oh, yeah. The other one is the right to face your accuser, which was also part of my notice. I have a right, by filing that notice into the court, to have the man or woman come forward that says I do wrong. I have the right to face my accuser. And then I also have the right to a trial by jury, because it says in the Constitution, the Texas Constitution, that that is inviolate. So they can't say I'm not allowed to face my accuser or have a trial by jury. And I wanted proof that they are bound to support them. So I'm asking for their proof that they swore an oath to uphold the Texas Constitution. Now here's 2 reasons why that's so effective. Because number 1, if they can provide proof that they swore an oath to uphold the Texas Constitution, well, now that secures your right to go about proceeding the way that you wanted to. And I would have still won, because if I had my trial by jury, there's no one to come forward. There is no accuser. I didn't do anything wrong. I would win. Now, if they can't provide proof because they never swore to uphold the Texas Constitution, well, now I just exposed that they're fraudulent, and they are operating under color of law. So I also win that way as well. So that's a pretty big one. And you're going to have to, rewrite this to your own specific situation and your own specific state constitutions. I had to actually go and look up the Texas Constitution and figure out which ones I could use. Everybody has to do their due diligence. Okay. So, what else do we have? Please understand that I wish to resolve this matter as soon as possible. I realize that I may have made a few mistakes in the past, but seeing now the need to exhaust my administrative remedy and process, I now require the above proofs of claim that you are relying upon to support your claim of action in this matter. Per your due diligence or acceptance to bring forth proof of claim, you will be found in formal acceptance, and will have admitted a damage and injury to this private woman, and will have stipulated to the facts that the private woman herein is not subject to the Texas Vehicle Code, and that she has a right to travel in her private automobile conveyance and non-commercial use of same. And as to any monetary and or pecuniary fine, that the undersigned can only discharge the monetary accounting penalty in behalf of the person debtor named on the charging instrument. You are required to send proofs of claim to the undersigned and a copy to the third party. The undersigned herein respectfully requires the prosecutor to reply within 10 days from receipt of this presentment, plus 3 days return service to respond. General acquiescence is as a non-response shall be taken as an acceptance to provide proof of claim, and forthwith shall constitute agreement by the prosecutor that the undersigned secured party can exercise the remedy provided by Congress via HJR 192 to discharge debts dollar for dollar with a draft, time draft, bill of exchange, or accepted for value, and return for discharge as necessary. And that the undersigned's exclusive remedy, if necessary, is tort, to be governed by the terms of the notice of claim presented by claimant appertaining to the matters relative hereto or otherwise. Best wishes, without prejudice. And I signed it as TTEE. And if you'll just give me 1 second, the white noise I have for my son just turned off. Okay. So this is how I signed it. There's my name and TTEE. And at the time I had a different, like the first private trust that I had set up, I only had one word for the name, and I realized I couldn't copyright one word. So I decided to make a new one. They didn't even notice that I had used 2 different trust names too, because on this one I was still using the first one, and on the rest of them I was using the second one. But I mean, you're allowed to do that, right? So anyway, for the so-and-so private trust, secured party, comma, creditor, I really can't emphasize that enough. I see people talking about a secured party creditor all the time, and they say it like it's 3 words in one, but it's actually 2 different things. You can be a secured party, and then you're a creditor. You know, it's 2. There's a comma there, because if you look up the definitions, there is no such thing as a secured party creditor. There's such thing, you can look up a secured party, and you can look up a creditor. Okay, I'm done with that rant. So then I signed it as the authorized representative, attorney in fact, in behalf of the all caps name, aka all caps name, because I've got married. I have 2 different ones. Okay, and all derivatives thereof. Ens legis. Ens legis means a creation of law. That's what those debtors are. It's a fictitious entity. It's a creation of law. So it's an ens legis, and I am saying I'm the authorized representative, attorney in fact, in behalf of them and all derivatives thereof. So if it's written with 3 uppercase initials, or a first name, middle initial, and then last name, or if it's last name and then first initial, you know, they have so many different ways where they write the name. So I just cover all of the versions, all the derivatives. And then of course I've got this little fancy gold sticker with my embossed seal on it. This is my family crest. Many people know this, but a roach is actually a type of fish from southern England. So there it is. There's 3 of them, and it represents a generous mind, which I think I do have because I like sharing facts and information. So anyway, all right, I sent that off. This is what I got back. Dear Ms. Roach, be advised that I and the City of Santa Ana are in receipt of your latest certified mailings. Although I appreciate all of your research efforts, I love that. In attempting to subvert Texas and the City of Santa Ana, Texas's laws and regulations for the public safety, be advised and that you will still be held to account for your speeding violation. Be further advised that I have reviewed the videotape of your stop by the officer in Santa Ana. I observed that you did admit to the officer that you were speeding at the time you were pulled over for speeding. You did have proof of insurance, which you did provide. However, you had failed to secure a valid Texas driver's license after being in the state for more than 30 days. It is understandable that you, as a single woman with a child, have... I'm not a single woman either. I'm married, and I was then. Just wasn't traveling with my husband. With a child, have to deal with the challenges of the pandemic in Texas. However, you're required to attempt to comply with the traffic and driver's license requirements of our state. It is my hope that you will be able to obtain a new driver's license issued by the state of Texas prior to your trial. I will be scheduling a pretrial conference for you in the near future, which will be done over the telephone prior to the trial which you have requested. As you may know, the governor has limited municipal court proceedings during the pandemic. Regardless, we shall afford you a day before Judge Shirley Rankin in accordance with the law. There's a second page to this, but I want to point out she said, be advised 3 times. I didn't even consider this necessarily when I was reading it until just yesterday when I reread it. She's trying to give me advice as a lawyer, as if I'm her client. And in case nobody's ever broken this down to you, if you know anything about court terms, what they'll try to say if you're representing yourself is you're called pro se. But look at how they spell prosecutor. Pro se cutor. Okay? Why do they have pro se in their name? And thanks to watching Patrick Devine, which you can find him on the YouTube channel Radiant Clone. I love his videos. Very smart man. And even though maybe some of his information is outdated, or as you watch through the videos, you can see some of the mistakes that he's made, I love it anyway. You learn so much just from listening to the guy, and he's a hoot. He's a total riot to listen to. He always cracks me up, makes me laugh. You can still learn a lot from just listening to anybody's testimony of what they've tried, what worked, what didn't. It's just amazing. So I definitely recommend watching his videos. But because of him, I learned that these city prosecutors are swearing an oath to represent both sides of the court. So this lady has sworn to represent me, whether I even knew that or not. And so here she is saying, be advised, be advised, be advised, over and over and over. She's trying to advise me as a lawyer, as a prosecutor, okay? Like, this is so just crazy sometimes to really wrap your head around this. It's interesting, too, that in the first letter she says the governor says no jury trials. And now here she's backtracking, says there's limited proceedings. Okay? Again, trying to scare tactic that we know you did it. We know you're guilty already. Just admit it. Just admit it. You know, whatever. Okay. So here's the second one. The video of your traffic stop is an admissible admission against interest. Should the judgment be against you, You not only will incur the fine and penalty associated with your violation, you will be liable for court costs. Okay, here we go. After a review of the traffic stop, Judge Rankin did say that she was willing to reduce the fine to a total of $200 for a plea of guilty. That amount reduces your fine to $66. The remainder is fees that the city of Santa Ana pays to the state of Texas. Please advise me if you are willing to remit the total fee of $200 or if you would prefer to proceed to a pretrial hearing prior to final setting of this matter for trial. Thank you sincerely, Elizabeth O'Connor. Okay? There's a couple things here. One, I forgot to talk about the fact that the court clerk actually admitted that they were having problems with me because I didn't have a Texas driver's license. I only had a Nebraska one. That was actually messing them up from being able to go against me. So she actually gave it away that by not having that driver's license, it was actually making it more difficult for them to pursue this. Okay. And as you can see, she kind of gives it away too by she admits, it is my hope that you will be able to obtain a new driver's license issued by the state of Texas prior to your trial. Because she is hoping I would do that and then they could get me. Because once you sign for that driver's license, you're accepting the benefits and privileges and agreeing with a contract. You're in agreement to following the codes. If you don't agree to follow the codes don't apply to you. That's just how it works. Contract law is everything. Once you sign that contract saying you're going to agree to the codes, if you violate a code and then you don't want to be punished correctly and justly, you're in breach of contract because you said you would follow the codes. So they were actually having a hard time with me because I didn't have that. And then here we go. This is when I really knew, hey, wait a minute, they're scared. Because all of a sudden they dropped it $200. And that's just, I remember thinking, man, maybe I should just pay that. That was my first thought, I think anybody would. They'd just be glad that the $200 got knocked off and call it a day, right? And then something got me. I said, wait a minute. If I just pay that and I'm admitting to guilt, then I'm in dishonor. And I'm also a liar because I said I'd pay the whole thing. I just needed her to prove a couple things and I'd pay the whole thing. So they're admitting they can't prove all that stuff. This is the admittance that they can't prove what I asked them to. So they're trying to drop it and hoping I'll take that. And I was like, no, I'll pay the whole thing. I need you to prove some things. So this is what I sent. Notice of fault and opportunity to cure and contest acceptance. Dear Elizabeth O'Connor, on January 21st, 2021, the undersigned secured party caused to be sent to you a conditional acceptance for proof of claim, CIFV, received and signed by you on January 25th, 2021, because I had her little signature green card receipt. She signed for it. So according to postal rule or mailing rule, she agreed. That's a private contract now. You failed to perform after receiving these presentments from Catherine-Marie Roach. And you failed to perform by providing the requested and necessary proofs of claim in the required 10-day response time, plus 3 days return service, and including ample extra time during the recent severe winter storm. As a respondent, you are now in fault, and you are in agreement and have stipulated to the terms of the undersigned's dated presentment through your dishonor. You have the right to cure this fault and perform according to the said terms within 10 days from the postmark of this notice. Should you fail to cure your fault, I will establish an affidavit of default, agreement, and failure to contest acceptance, and obtain an affidavit of certificate of non-response pursuant to and relative to UCC, state statute, and otherwise. Thank you for your prompt attention to this matter. Best wishes, without prejudice, and there you go. I signed it, blue ink, red thumbprint, TTEE for the private trust, secured party, creditor, authorized representative, attorney in fact, in behalf of, all caps name, aka all caps name, and all derivatives thereof, ens leges. And then there's my gold seal again. And then this is a copy because I was in such a hurry to get this written up and sent in. I never actually made a scanned copy of my original, I guess. Or I can't find it. I know I've got it somewhere because I keep copies of like everything. So what I did is I just went to my Google Drive where I had originally typed it up, and I printed it out, stapled it, and copied it. But of course, I would have had a bracket also. So here we go. Affidavit of notice of default. I sent this to her, and I sent this to the court clerk, and this was it. I never heard a single word ever again, and this is what everybody's been wanting to see so bad because I fired her, okay? I fired the prosecutor and never heard a single peep out of her ever since I filed this. And I don't have any warrants, okay? And I've never gotten a Texas driver's license. And the Nebraska one expired. And knowing what I know now, and you'll see it written in here, I'll never ever have a license for anything. The license makes it legal for you to do something that was otherwise unlawful. So that's kind of sketchy too. Anyway, affidavit of notice of default. Notice to agent is notice to principal. Notice to principal is notice to agent. Indeed, no more than affidavits is necessary to make the prima facie case. United States versus KIS 658 F 2nd 526 536 7th Circuit 1981. Cert denied 50 US LW 2169 S Court or Circuit March 20, or I guess that would be Connecticut. I don't know. March 22nd, 1982. Sorry for that. I guess I shouldn't read that part, but I did it anyway. Catherine, I will only use my first name in this section. Herein affiant, a living, breathing woman, being first duly sworn, depose, say, and declare by my autograph that the following facts are true, correct, and complete to the best of my knowledge and belief. Number one, that affiant is competent to state the matters included in his or her declaration, has knowledge of the facts, and declared that to the best of his or her knowledge, the statements made in her affidavit are true, correct, and not meant to mislead. Two, that affiant is the secured party, superior claimant, holder in due course, and principal creditor having a registered priority lien hold interest to all property held in the name of debtor, all caps name, aka all caps name, evidenced by UCC 1 financing statement, amended filing number. See, I had to amend it, so I had two filing numbers for it so that they could actually view both of them and see the amended one and the original initial filing. So then I put the initial financing statement filing number filed with the Secretary of State in the state or of the state of Texas. 3, that respondent Elizabeth O'Connor is herein addressed in her private capacity and in her public capacity as I'm making a video. Sorry, I'm almost done. Okay. And in her public capacity as city prosecutor of the city of Santa Ana, participating in a commercial enterprise with her co-business partners or employees, including but not limited to the state of Texas, a corporation, and hereinafter collectively referred to as respondent. 4, that the governing law of this private contract is the agreement of the parties supported by the law merchant and applicable maxims of law established by silence, acquiescence, and tacit agreement. 5, that affiant at no time has willingly, knowingly, intentionally, or voluntarily agreed to subordinate their position as creditor through signature or words, actions, or inactions. 6, that affiant at no time has requested or accepted extraordinary benefits or privileges from the respondent, the United States, or any subdivision thereof. 7, that affiant is not a party to any valid contract or compact with respondent that requires affiant to perform in any manner, including but not limited to the payment of money to respondent, nor has respondent disclosed under good faith any contract, agreement, or otherwise to show that the affiant is required to perform in such manner. 8. That on or about January 21st, 2021, affiant sent a conditional acceptance for value for proof of claim document for discovery to the respondent requesting proof of claim as to the authority, jurisdiction, and in what manner affiant is to pay debts at law and or discharge of debts, with requests for the respondent to produce and provide proofs of claim and other various proofs of claim to support respondent's presentments and or a valid lawful contract and claim. 9. That respondent had 10 days to respond with proof of claim, point for point, however, elected to remain silent or otherwise refuse to provide said proofs of claim, and therefore has failed to state a claim upon which relief can be granted, and has agreed and stipulated to the facts and agreed that the undersigned secured party can only discharge said debt via the remedy provided by Congress via HJR 192, June 5th, 1933, with bill of exchange or other appropriate commercial paper. 10. That respondent is given an additional 3 days to contest respondent's acceptance as to the stipulated agreement based upon silence, acquiescence, and therein tacit agreement that all the affiant can do is discharge any state of Texas tax liability via bill of exchange, bond, acceptance for value, and returned for discharge, or other appropriate commercial paper. 11. That the respondent is noticed that respondent is in default, failed to contest acceptance, and is in agreement to the undersigned. 12. That the respondent's last presentment, dated March 8th, 2021, was silent of any proofs of claim and considered a failure to produce and provide said proofs of claim. She continued to express my failure to secure a valid Texas driver's license even upon my asking for proof of claim that the Texas Department of Motor Vehicles can offer any other driver's license besides a commercial operator's driver's license. However, it seems to contrast the following. Please compare to: no state shall convert a liberty into a license and charge a fee therefore. Murdoch versus Pennsylvania, 319 U.S. 105. If the state converts a right, a liberty, into a privilege, the citizen can ignore the license and fee and engage in the right or liberty with impunity. Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. 13. That it still has not been mentioned if this is a civil matter or a criminal matter, both of which require an injured party and some sort of harm. I wish to know who I have done harm to so that I may compensate the man or woman properly, but an accuser has yet to come forward. 14. And this is where I really nailed it, and this is what everybody's been waiting for. I fired this lady. That the city prosecutor named Elizabeth O'Connor is a third-party witness and therefore only has mere hearsay to contribute to this case. Furthermore, in the event that she has sworn an oath to represent both sides of the court, she is hereby fired, that is, terminated from any presumed power of attorney, null and void ab initio for lack of full disclosure. It is my express wish that either any and all debts owed be discharged lawfully, rightfully, and correctly, that an accuser comes forward before an open court and verifies that I do wrong, or this matter be dismissed with prejudice, so that I can continue to be let alone to live peaceably in my private capacity. Further affiant saith not. Dated, without prejudice. I signed it blue ink, red thumbprint, put my seal on it to the side there on the left, and got it publicly notarized. And that's it. And as you can see, every time she would send me a letter, she actually sent it certified mail, signature receipt requested. And she actually used non-forever stamps in the amount of $7. So every time I sent her every time I sent her something back, I did the exact same thing. I don't think she knew that I was going to know about certified mail and non-forever stamps. So I just did it back. And I only sent in 3 things. So, and $7 each time. So it cost me $21 instead of $66 and instead of $284. And I learned a lot. I learned a lot by doing this. And now I can share that with everybody else. So that's my story. That's what happened. Sorry it took so long to get this. We had to get a new computer. Nothing was recognizing that my printer could scan also. We had a laptop and an old computer and they wouldn't let me scan anything, so it took forever. I finally got everything scanned. Then I had to The next day I had to redact all my private information. And then the next day I was going to make this video, but the baby never took his nap. And then today he took his nap. So I finally got the video, and y'all don't need to know any of this information. I'm just trying to say thank you so much for being patient, bearing with me. I hope this is helpful. I hope it helps so many other people. And the truth is, I kind of stopped it prematurely. The truth is, I really could have pursued more. I'll just be honest with you. I wasn't exactly sure how to use a notary you can use them as some sort of process server. They become like your personal witness to the non-response. You kind of get them involved somehow, and I didn't really know how to do that, so I just let it go for this. I was pretty happy just to like have them off my back, because I had so much other things that I was trying to do. I'm a busy woman, you know, and I just don't want to deal with all the stress and extra paperwork and just being hassled, you know. So I was really proud of myself just for this alone, because I felt like this was the first time I was really executing the trust as the trustee, because I had filed a Form 56 as fiduciary over the trust. So I viewed this in all actuality and sincerity that I really was trying to secure the trust assets, and I wasn't about to like let somebody nibble off of the trust assets. And that's how I viewed it, that they were trying to take 285 away from the trust, and my trust beneficiaries are my children and my sons, you know, so they are my heir. They are the heirs to the trust, and so that's their money, and somebody else is trying to nibble off of their inheritance, you know, not gonna fly. So I really kind of gave it my all, and I probably could have made money off of this case if I really wanted to. I could have taken it further. I wasn't really sure how to do it, and I wasn't that interested in it. I've got so many other things that are my main focus and my main concern. So if anybody wants to share their information, I'm always interested in learning more about this stuff. I'm always interested in expanding my private law education, and I hope everybody else does the same. It's really amazing. It's been so eye-opening. I see the whole world in a totally different way. Everything's contract law. All right. Thanks, everybody. Take care.